Let's start with this one. We recently saw the recent developments made by investigations conducted by firm Bowmans and the Special Investigation Unit. This was relating to dodgy tenders at Eskom over the past 10 years, resulting in 178 billion rand graft. Now, the investigations found a slush fund created by former executives where they had monies paid for various aspects of their lives. One of these cases involved a company named Tubular Construction, which supplied services to Eskom over contracts worth 1.2 billion rand, and a multinational company called Babinatlou Business Solutions, which also received millions. Now, how are monies located and traced? Now, joining us to discuss this further is Investigator at IRS Forensic Investigators, Chad Thomas. Chad, really appreciate your time this morning. Let's start there. How, when there's such a massive case, so many bank accounts involved, I believe about 250 of them, how on earth do you trace money, especially if it's offshore?
Good morning to you all firstly, and happy Mother's Day to all the mothers out there. Complex financial crimes are nothing new, but what is new is the fact that there's such incredible legislation both in South Africa and worldwide, and organizations, both public and private sector, that have been brought into the fold to investigate where the money goes. One always hears the term when investigating financial crimes, follow the money. And that's literally what happens in a complex financial crime investigation. It's referred to colloquially as a money thread analysis. I don't know if you guys remember back to the 80s and the 90s when you had these spy shows and these FBI type shows in America. And there'd literally be a green board up and there'd be a thread. There'd be a pin with a thread to another pin, with a thread to another pin, and it would all link these different parties, these different banks, these different organizations. And that's where the term money thread analysis comes from. And it's still a very well-used term within financial crime investigation circles. So we're very fortunate. We're signatory to various treaties that have been set up worldwide that ensure that money can be traced. And that's very important. We live in a digital age, and as members of this international digital financial crime investigation community, there's many tools that are available to be able to trace the money. South Africa in particular has various organizations that are responsible for this from a state perspective. One of the most important is the FIC, the Financial Intelligence Center. Everybody thinks the Financial Intelligence Center is there to enforce FICA and to make our lives difficult in opening bank accounts, etc. Well, that's not actually their prime reason for existence. They're actually an intelligence-driven investigative entity, and they have very strong powers. If they identify bank accounts where monies may have been laundered in terms of anti-money laundering legislation, they can issue what's known as a Section 29 notice to a financial institution for those funds to be frozen, and those funds are then held, very similar to a temporary restraint that can be applied for by the asset forfeiture unit, which can become a permanent preservation order. Now, of late, we've seen how effective South Africa is on the international stage in respect of monies that have gone offshore. If one looks at the Ronald Bobroff and Daryl Bobroff case, which involves two fugitive attorneys from South Africa who fled to Australia, who were implicated in a massive alleged fraud involving the Road Accident Fund, 100 million rand of their funds were frozen. That was made permanent just less than 2 weeks ago in the court. They had appealed this, even though they weren't in South Africa. They instructed attorneys, and our courts and our learned judges upheld that preservation order, and it's now a permanent order, and those funds have been frozen. So it shows that our local authorities can have clutches that reach worldwide. So we're very fortunate to have legislation in South Africa, such as POCA, the Prevention of Organised Crime Act, such as FIC, the Financial Intelligence Center, and of course, PRECA, the Prevention and Combating of Corrupt Activities Act.
Now let's talk about the case that you're referring to that just got wrapped up about a couple of weeks ago. That money has been frozen, but what happens to the fugitives, so to speak? Do they remain in Australia, if that's where they are at the moment, or will something then also be done on top of freezing their assets to extradite them back to South Africa?
So these are all parallel processes, and there's all these different divisions of South African law enforcement working together in effect to be able to make extradition, to make reparation, to ensure that there's a form of restorative justice that takes place. So the asset forfeiture unit has a component that, together with the Interpol component of SAPS will apply for an international extradition order, which will then be loaded onto the Interpol system known as a red notice. We saw that recently where a person was extradited back to South Africa in respect of a very well-known case involving funds misappropriated from the public sector from one of our SOEs. He was brought back from England. He will be standing trial. The asset forfeiture unit function is separate to that. They're there to ensure that there is a temporary restraint and thereafter a preservation order issued in respect of poker to ensure that those funds are secured and can be brought back into South Africa. And then, of course, you have the investigative component that is investigating in what we now call prosecutorial-led investigations. So you'll have the ID working together with their counterparts at the NPA or the DPCI or the Special Investigating Unit, all working in conjunction with the prosecutors to ensure that there's going to be a successful prosecution. And this is very important, and this is a massive development in South Africa, because we always talk about intelligence-driven investigations and prosecutorial-led investigations, but these don't necessarily happen. What we are now seeing with the recapacitation of these units is that this is now happening, where you have a team that's put together with a nodal point, and that this joint team, very similar to what we used to have in terms of the ACT team, the Anti-Corruption Task Team, is that they are now able to work locally for the same ultimate objective, but that they're also able to work with the international counterparts, such as the Financial Action Task Force, which has been established as a worldwide nodal point for all recognized law enforcement agencies that are involved specifically with AML, which is anti-money laundering, and money threat analysis, which is the tracing of those funds.
Now, Chad, judging by what you're saying, South Africa, we haven't been able to do this for the longest of time. This is sort of recent developments. I'm not sure how recent, and you'll let me know. But this brings me to my next question then. If there was money laundered and moved offshore, say 10, 15, 20 years ago, can it still be traced? How far back can you go? And what would that process look like?
Okay, so that's an interesting question, and it brings us to a very interesting point, as in to how do you hold the banks accountable. We've seen issues pertaining to allegations with Nedbank acting as a clearinghouse for various Gupta-linked organizations that funds went straight to a bank known as the Bank of Baroda. We've also seen similar instances in the private sector where massive fraud targeting private citizens in South Africa, known as Global Electio, also used the Nedbank platform purely as a clearing account in South Africa, and funds were then taken out of that account and straight to Bank of Baroda as well. Now, this is an important issue because there are reportable functionalities that the financial houses have in terms of their accountable status in terms of FICA. So they have to report certain things. And in some instances, this hasn't been reported, or there's just been so many reports that they haven't been able to investigate each and every report. So there are a couple of reports that we need to look at. The first, of course, is the Section 29 report in terms of FIC, which is a suspicious transaction that an accountable organization makes. Another report, which is extremely important, is the Section 34 report in terms of PRECA, which is the Prevention Combating of Corrupt Activities Act, which has got two parts to it. The first part is to report a suspected corrupt act that may have taken place, and the second part is to report a suspected fraudulent act over 100,000 rand that may have taken place. So our banks in South Africa all form part of an international group, and there's meetings held on a semi-regular basis, and we refer to them primarily as the Basel Accord. So Basel is a city in Switzerland, and that's where most of the banks meet, and they discuss anti-money laundering legislation. They discuss what the governments of their respective countries expect of them, and internationally what the treaties that have been put together require in respect of this reporting. And there's quite an interesting sanction that can be applied to banks that don't cooperate in respect of providing information that's been requested, and that is that their SWIFT code can be taken away. And it sounds kind of petty, it sounds kind of minor, yet sometimes it's the most simple things that can have the best result. If a bank has its SWIFT abilities taken away from it, they basically cut off at the knees. They're not in a position to be able to receive and transfer money on behalf of their clients on a worldwide basis. So this is one of the immediate sanctions that can be imposed on banks. Going back to your question, how far back can we go? Well, there's a dilemma. Different jurisdictions have different requirements. Some jurisdictions are 5 years, some are 7 years, some are 10 years. But we live in a digital age, and it's expected and incumbent upon these organizations that are entrusted with monies that could have come from the public purse, it could have come from the coffers of SOEs, etc., to keep and maintain records. And it's not just those records that are maintained, it's also the accounting officers within those organizations, the internal audit function, as well as the external auditors. And when one starts looking at the complex web of how special purpose vehicles are set up to launder funds, one will see that it's not a very easy exercise to go out and to examine this complex money thread analysis. But living in this digital age, living during the times that we are, it's also not that difficult if one has the sufficient tools. And law enforcement has tools that allows them to access on a legal basis most databases. And then, of course, individual independent investigators working in the private sector can access open source intelligence, they can request information, they can work together with the authorities, and together they can track and trace the money. One of the primary things in South Africa is what we term a lifestyle audit. It was a term that was coined many years ago when SARS was fully functional in respect of their investigative capacity, and it looked at the most obvious. It looked at whether a person's lifestyle matched what their earnings were. And in those days, you even had a team of members at SARS that went from high-tech ways of trying to uncover complex webs of crime to literally having people read newspapers, read magazines, look at the gossip columns, look at social media when it first emerged, start looking at the people's lifestyle, where they holiday, who they holiday with, what new cars are they driving, where are they staying, those type of things. And they've now been able to take that simple way of performing an initial lifestyle audit from a periphery perspective into something far more holistic, where they can now basically tap into all these other systems. And I believe SARS has recapacitated itself to the extent that they're going to be looking specifically at high net worth individuals whose earnings don't match necessarily that of what they're declaring to the taxman, as well as the involvement of private sector companies that have been appointed in terms of the bid and the adjudication process to SOEs and to other state entities to provide services.
Important recapacitation by SARS in that regard. Apart from tracing money, what else can forensic investigators do? I understand, if you look at this Eskom saga, there's almost 30 terabytes worth of information on emails, for instance, that's been gone through with a fine-tooth comb. What else, and what other ways do you go about your forensic investigations?
So it's a fascinating question because it pertains to how the information that's out there gets examined and how you then identify the red flags or the anomalies, or what we like to refer to as the exception reports. So going into the cyberspace and having a digital audit is not a simple process, but it's a process that can occur. And within the South African context, there are multiple law enforcement agencies, intelligence agencies, and private sector organizations that have the necessary licenses to be able to perform these functions. This is all about pulling as much information as possible. I call it colloquially doing your homework. So when I speak to my investigators, I say, let's do our homework first. And by doing our homework, we're talking about pulling information from open source intelligence sources, from databases that we have access to, and then, of course, communicating with our counterparts that work within state law enforcement and seeing how far they are and where we can assist and where we can add value. Normally what will happen is a project or an inquiry will be registered by the authorities should they have received a Section 34 report in terms of PRECA, or should the FIC have received the report and thereafter issued a Section 29. And together, if the correct orders are in place, and the correct permission has been granted by the higher authorities, then the search begins. And that's when it becomes fascinating, because you start looking at familial links, you start looking at associated entities, you see what companies are linked to what. And that's when that beautiful organogram gets created. And that organogram we refer to as a spidergram, because it's more of a spider web. And you start seeing how this organization paid funds to that organization, but the funds originated from a SOE or from a state enterprise or from a bank, and you then see where those funds go, what those funds pay for, how some of them go into trusts, how some of them go into overseas bank accounts, how some have been used to purchase vehicles, how some have gone into property owning special purpose vehicles. So it's a fascinating exercise, but it's nowhere near as complex as one would imagine. And although we use the term complex financial crime investigation, that refers to the fact that it's a bit more difficult than your normal fraud or misappropriation or embezzlement that's taken place. A complex financial crime means that there are layers involved in trying to uncover how the money has in fact been laundered. One must understand the critical...
Chad, unfortunately, we have run out of time, unfortunately, but I mean, a very complex conversation to be had, and it's multi-layered as well, but that's where we'll leave it for this morning. As an investigator at the IRS Forensic Investigators,